Alors bonjour tout le monde. Good day. Today we have the chance to receive as a guest Me Felicia Marino from our law firm. Welcome.
Hello, Gagnon.
Today we will be talking about access and use of the yard or the land for a tenant. What is their rights and the obligation? First of all, can you present yourself, Me Marino?
So I've been here with you and with the firm since July 2014. We specialize in real estate law, particularly, as you know, in rental board cases, but as well in cases of latent defects with the purchase or sale of a home.
Thank you. So can you explain to the people who are listening to us, is it important to talk about the access of the yard or the land, and where should a landlord put specification?
I think that it's often something that is overlooked by a landlord. And in the lease itself, in section E, there is a condition where you can indicate if the tenant has the right to access the land. So there is the option to put an X on the yes or the no, and then also to indicate certain precisions according to that. Oftentimes, landlords don't mention anything, which then leads to problems and conflict.
Okay, so let's say a real case, the landlord noticed that there's a pool has been installed in the backyard of his building. What should he do?
Well, first of all, even if your tenant has the right to access the land, it's important to note that any certain installation, whether it be a permanent or temporary, still needs to be approved by the landlord as it still remains his property. And you can indicate that as well in the lease, or make a note that you're referencing to the building regulations, which are available on the CourtPick website.
Okay, but let's say another situation. Okay, there's nothing indicated in the lease. There's no regulation that states that whether they can use the backyard or not use the backyard. But should a landlord go to the rental board immediately, or what?
Well, if in the case where she installs a pool, for example, you should always, and she has not a right to do so, first thing you need to do is to obviously send a notice to the tenant to indicate that it is without permission that she has done this installation. And also note that it could impact as well your insurances on the building. So it's an important factor that you need to take in, and you need to react right away.
Okay, and do you know how long it will take for a landlord to apply to the rental board to ask the court to make a stop to this situation?
So if she doesn't react, or the tenant doesn't react following your letter, your formal letter, you must file a demand at the rental board with an order asking the tenant to conform to his or her obligations according to the lease and the law. The delay in times for a hearing depends obviously on the area in which you are located, but certain cases are taken with more caution and are treated with urgency, but you can expect a certain delay before having a hearing.
Well, we thank you. It was very inspiring, and have a good day. Thank you.
Thank you.